For what? Under what section?
Section 1 of
Section
the
1?
Criminal Evidence Act.
Why?
Because I need to stop searching.
What's your reasonable grounds?
The reasonable grounds are I need to make sure that you don't
Why are you
have anything
shaking?
on you.
Why are you shaking?
Just listen to me, please.
I'm listening to you, let go.
I'm not going to let go of you.
Welcome back to Camera Never Lies, the channel exposing police misconduct and demanding accountability from those entrusted with public power. Today's footage comes courtesy of Free Times Audits, and you'll find a link to their channel in the description below. Be sure to check out the original video and show them your support. In today's case, an officer rushes out of Bolton police station and immediately lays hands on an auditor despite having no identifiable offense, no reasonable grounds, and no lawful justification. He relies on a legal power that simply does not apply, removes the auditor's face covering without any authority to do so, and then, in the closing moments of the encounter, unintentionally reveals on camera the real reason behind his actions. That admission ultimately led to his force paying out a settlement. With that said, let's dive straight into the footage.
He's going to get the silent treatment.
I'm a police officer, come here please.
No, you can't tell me what to do.
Why are you filming the police station? Why are you filming the police station and all the vehicles? I need to know who you are.
No, you don't.
Make sure that there's nothing sinister going on here.
There's nothing sinister going on.
Well, can you just come with me a second?
No.
I'm not coming down there with you, I need you to just come here.
No.
Can't say that.
No.
Well, should we have a-
Am I being detained?
You're not being detained.
Right, then I'm leaving then.
I need to know who you are and why you're filming the police station.
Within the opening moments of this encounter, the auditor follows the rules completely. He politely asks the officer for identification and requests his collar number. Then, after being clearly told that he is not under arrest or detention, he does exactly what the law permits him to do. He leaves. That legal principle was established in Rice v. Connolly, 1966, confirming that members of the public are not required to answer police questions, provide their personal details, or remain in place during a voluntary interaction with officers. Walking away from an officer who has no lawful grounds is not obstruction. It is not suspicious behavior, and it is not an attempt to escape. It is simply a person exercising a legal right. And when it comes to filming a police station from a public place, the rules are just as clear. Standing on a public pavement and recording what can be seen from that location is not, by itself, a criminal offense. There is no law that automatically prevents it. Remember that point, because everything that happens next is based on an allegation of wrongdoing that has no legal foundation.
Why have you got your face covered? You can quite see.
Why have you got your body covered?
You can see I'm the police officer.
Who are you? What's your number?
11070.
What are you doing?
Why are you filming
Get off
the
me!
police station?
Get off me!
No, I'm not. Why are you
Get off
filming
me!
the police
Get
station?
off me!
Why?
Get off me!
Why
Get off
are
me!
you filming the police station?
Because I can.
I need to make sure that you have nothing sinister going on.
Right, am I being detained?
At the moment, you
Right,
are, yeah.
for what? For what? Under what section?
Section 1 of
Section
the
1?
Criminal Evidence Act.
Why?
Because I need to stop searching.
What's your reasonable grounds?
The reasonable grounds are I need to make sure that you don't
Why are
have
you
anything
shaking?
on you.
Why are you
that
shaking?
presents- Just listen to me, please.
I'm listening to you, let go.
I'm not going to let go of you.
It's assault, this.
It's not an assault.
It is assault.
Come with me, please.
Why?
Because I'm telling you, just come with me.
No, you just detained me, so I'll stay here.
Well, come with me, please.
Are you arresting me?
At the moment, no, but please come with me.
Why?
Just come with me.
Why?
Because I've got a colleague coming.
What? Right, well, you can come here, can't he?
Well, let's see who you are.
What's your reasonable grounds?
I'll explain what the reasonable grounds are.
What are they? That I'm taking pictures?
Yes.
Oh, that's a crime, innit?
And this is where the situation takes a serious turn. Physical contact happens first, and the legal justification appears afterward. Under Section 1 of the Police and Criminal Evidence Act 1984, officers do have the authority to stop and search an individual. But that power is not unlimited. It requires reasonable grounds to suspect that a person is carrying specific items, such as stolen property, prohibited articles, weapons, burglary tools, or other evidence connected to a particular offense. The key word is reasonable. Pace Code A makes it clear that reasonable suspicion cannot be built on assumptions, instincts, or vague impressions. A simple hunch is not enough. A person recording in public is not enough. Someone choosing to cover their face is not enough. The law does not allow officers to rely on stereotypes, personal opinions, or generalizations about a person's behavior or identity as a substitute for actual evidence. And that is the critical issue here. The power to stop and search must come from specific facts, not from a feeling that something seems unusual.
Of the police station and vehicles, private vehicles and police vehicles.
That's not a crime. That's not a crime.
Hands now.
What, my hands are
Rules
here.
for the movement, you understand?
Yeah.
Right, you got a detail on you.
Stop tensing up, pal. Stop tensing up. Do as you're told and do it now. Do as you're told.
If you just listen to what he says, just wait, let them. We're going to put the cuffs on now. Detain it for one time. Alright, just calm down. Alright.
Rules for the movements, pal. Thanks, Jim. Right, circumstances being, yeah, I've come in. I've caught him filming vehicles with his mobile phone. He's taking pictures of the entrance and around the back, filming the vehicles. So I've asked him to stop. He's walked down here. He's tried lowering me down there on my own. So I've stopped. Well, I've got a grip of him under section 1 apace. Yeah. Just to make sure that he's got nothing on him. Obviously, he's got his face covered. Yeah. I don't know what his intentions are. Yeah.
Now pay close attention to how the narrative begins to change. The auditor taking a few steps backward while standing on a public pavement, something he is legally allowed to do, is suddenly described as him trying to lure the officer away from the area. But that is not an objective account of what happened. It is an interpretation added after the fact. Then comes the most important statement from the officer himself. I don't know what his intentions are. Those words reveal the problem. The officer is openly acknowledging that he has no specific information, no clear suspicion, and no identified offense. He is relying on uncertainty rather than evidence. Not knowing someone's intentions is not unusual. It is the everyday reality of policing. Officers encounter members of the public every day whose thoughts and motives they cannot know. But if simply being unsure about someone's intentions was enough to justify a search, then the requirement for reasonable suspicion would disappear entirely. Section 1 powers would no longer be based on evidence. They would apply to anyone, anywhere, at any time.
I don't know who he is.
You've been told before. Are we right to look through your phone? Yeah. Okay, sir.
Yeah, good, are you?
Yeah, not too bad.
Establish who he is, what he's doing here.
I've just told you what I'm doing, yeah.
Perfect. Okay.
Get off. No, you're not allowed to do that.
I can't.
No, you're not.
Yeah, okay, it's a
You're not.
very reasonable line of inquiry.
No.
Perfect, right. You are being detained. Make sure you catch it.
Right, yeah, that's fine.
Okay.
I don't consent to the search.
That's right, you don't need to consent to it, alright? Because you've been filming this, we're not sure.
I've just told you my intentions. Yeah, can I have all your details?
Okay.
Right.
Everybody's details and your phone number? 17064.
Is that still recorded?
165.
This is the point where many discussions around incidents like this become inaccurate, so the details matter. There is a specific legal power that allows police to require someone to remove a face covering. Section 60AA of the Criminal Justice and Public Order Act 1994. However, that power does not exist automatically. It requires prior authorization from an inspector or a higher-ranking officer, applies only within a defined area, for a limited period of time, and must be based on a reasonable belief that offenses involving face coverings are occurring or are likely to occur. In this situation, no such authorization was mentioned. No officer claimed that a Section 60AA order was in place. One thing the auditor handled correctly was making his position clear. He stated that he did not consent to the search, but he also did not physically resist the officer. That is often the most effective approach in these situations. You clearly state your objection, you avoid escalating the encounter, and you allow the legal process afterward to determine whether the officer's actions were justified. And as this case continues, that decision becomes very important, because the consequences came later.
So you probably are going to attract some sort of attention and be asked some questions.
All your numbers.
Any questions or queries, sir, before we leave you?
Yeah, why was I detained?
We've just explained.
Can you
that's
explain
it.
again for the purpose of the film?
No,
No?
because everything's recorded, and as I've already explained, you are entitled to
For
it.
this, guys.
Yeah. That's where you've been handcuffed.
Yep, handcuffed, detained under what section? Section 1?
Section 1 of the Police and Criminal Evidence Act. We're not going to keep going over the same scenario. We've explained it to you. Have you any further questions, sir? No.
Tyrants. Abuse of power. There will be a civil claim going in.
Alright, sir.
Yep.
Have a good day.
Any
Off you pop.
questions?
Off you pop, 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 off you pop. Tyrant, off you pop. Am I free to leave? Am I free to leave?
You're free to leave.
I'm free to stay, aren't I?
I'll stay here with you then, sure.
Alright, yeah.
Have a good day. Let's see how long this lasts.
Assault, you assaulted me. Excuse me?
Trying to get through, sir. No problem.
Take care.
So I'm going to get detained again for video in the police station?
I'll advise you not to, which is why we stopped you, isn't
I
it?
don't take advice.
Well, you're going to get stopped again, aren't you? You can't walk round the police station filming personal
Yes, you
vehicles
can.
and private vehicles.
Yes, you can.
It's not advisable.
What law? What law
You're
is
gonna
it?
get stopped,
What
aren't
law
you?
is it?
We just explained it to you.
No, it's not law. You've not explained any law.
We have. We've explained
What?
it to you.
You can't take pictures?
I advise you not to.
That's your advice, isn't it?
Stop
That's your
every time.
advice.
You don't like getting stopped, then don't film police vehicles.
I don't think you're very clever, so I won't take your advice.
All right, take care.
You don't even
Have a
know
good day.
you don't even know the law yourself.
All right, have a good day.
Oh, and 1, 2, 3, 4, 6 police officers don't know the law, and a sergeant.
The moment the officer tells the auditor that he is free to leave, the legal authority to keep him there comes to an end. But watch closely what happens next. Instead of allowing the encounter to end, the officer continues to hold on to the situation, saying, "I'll stay here with you then." The detention is over. The legal basis has disappeared, yet the pressure continues. And then comes one of the most revealing moments of the entire incident. Multiple officers, including a sergeant, are unable to clearly identify the specific law that supposedly prevents the auditor from filming. When the auditor asks a simple question, "What law is it?" the explanation changes. It moves from "you can't film here" to "I advise you not to." And that difference is everything, because the entire encounter can be summed up in that one moment. It was not a clear legal restriction. It was advice being treated like an order, and an order being enforced with police powers.
He looks about 10.
Stop and a half.
Do you get them F put? You're right.
Yeah, you.
Yeah.
I'd like you to disappear, please.
I'm not a magician.
I feel very uncomfortable with a member of the public wearing a face covering, filming a police station.
Well, what do I do? Call the feelings, please.
Take care.
Uncomfortable. Off you pop.
Any further questions, sir?
Not for you.
No, thank you. Good day.
Which one's your car?
And that is the central issue revealed by the entire encounter. There was no clear suspicion, no specific intelligence, no named offense identified at any point, no lawful basis that was clearly established. What remained was simply a feeling of discomfort. And that is the difference that matters. A person's unease, uncertainty, or personal reaction cannot replace the legal requirement for reasonable grounds. Yet that feeling alone appears to have escalated the situation from a simple public interaction into detention, a search, handcuffs, and the forced removal of a face covering. The question at the heart of this incident is not whether the officer felt uncomfortable. It is whether that discomfort was supported by the law. Because police powers are not based on feelings. They are based on evidence, justification, and legal authority.
See that, guys? Section 1, detained. Muppets. Absolute Muppets.
3 times, orders later confirmed that the civil claim was resolved through an out-of-court settlement with a financial payout. Now, settlements do not automatically prove every detail of a dispute, but they do show that the force chose to resolve the matter rather than take it through a full legal battle. After reviewing the footage, the actions taken, and the legal arguments involved, the force reached an agreement instead of defending the case in court. According to Free Time's audits, the issues surrounding this incident included the physical contact before clear grounds were established, the use of filming as a reason for suspicion, and the removal of the face covering without any claimed Section 60AA authorization. FTA also reports that the officer involved no longer works at that station. But when everything else is stripped away, This entire encounter comes down to one simple exchange. The auditor repeatedly and calmly asked a straightforward question. What law are you acting under? And that answer never came, because throughout the encounter, no specific legal power was clearly identified. The consequence of that uncertainty was not paid by the officer at the roadside. It was paid later through a settlement funded by the public. Police powers are not personal authority. They are granted by law, and they must be used within those legal boundaries. When an officer reaches for enforcement because the legal argument has fallen apart, that is not the law being upheld. It is the law being avoided. If you want to understand exactly where you stand when dealing with police, including what officers can request, what you have the right to refuse, and the words you can use during an encounter, download our free UK rights cheat sheet linked in the description. It covers stop and search powers, filming in public, and the questions you are never legally required to answer. If you found this breakdown helpful, make sure to like the video, subscribe for more investigations, and support Free Times Audits by checking out their channel below. We'll see you in the next one.